Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery.
And my name is Brandon Mack. I'm the co-host of our podcast. Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome back to another NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. I'm Daniel Gold, and I'm here as always with my co-host Brandon Mack. Today, we are joined by Georgetown Law's Jonah Perlin. He is a legal writing professor, an ethics scholar, and a host of How I Lawyer. So if you're catching that, he's a fellow podcaster. So we are definitely glad to have him here on the program. His recent scholarship includes client confidentiality as data security and how the billable hour can survive generative AI. That is something that we are looking forward to really digging in with the professor this morning. And previously, he's litigated at Williams & Connolly and clerked for the United States District Court for the District of Columbia and the Second Circuit. And Jonah argues that in the AI era, the lawyer's duty of confidentiality has transformed into a duty of security. That is actually the first one that I've heard about that, and I think that is also particularly exciting. So we're going to explore all that and the means for discovery in courts and arbitration, for how we teach judgment and the craft of advocacy in a screen-first world. Professor Perlin, welcome to the program. We're so happy you're here today.
Yeah, thanks for having me. I appreciate the introduction, and more importantly, appreciate the opportunity to hang out on the other side of the podcast mic, as it were.
Well, that's great. Jonah, I want to start here. So you have said that generative AI is simply, and I use that word intentionally, is simply the next turn of the wheel. So from books to Boolean to natural language search, when you look at litigation and arbitration through that lens, what's the through line then that defines good lawyering, no matter how advanced our technology has become?
Yeah, I mean, I think it's a great question, and it's a fair question, and it's a question that, frankly, I think every lawyer ought to be asking themselves. One of the great parts about studying technology, especially new technologies from the perch of sort of an academic post, is that my default is to look at history as a guide, right? I love the phrase that history doesn't repeat itself, but it rhymes. I think that's absolutely true when it comes to technology and law. And in my last article, which I confess took several years, and that's probably understating how long it took to write, about client confidentiality and data security, which I wrote pretty much all before the advent of generative AI, or at least not the advent, but at least the mass adoption of generative AI. I went back to the question of where did the duty of confidentiality come from and how was it affected by technological innovation? And so it really made me do sort of a deep dive on lawyers and technology, which I think has been, frankly, understudied. There's kind of an exceptionalism of the day and age we're in. If you're a lawyer pre the advent of the telephone, that's a very different profession than a lawyer post the advent of the telephone. But at the same time, and I'm hearkening back to something that Professor Emery Lee wrote in a law review article. We have not changed as a profession quite as much as many other professions, in the sense that we still exist, we still are filing lawsuits, we are still helping our clients do deals. So to me, it is both the next turn of the wheel, to sort of use your phrase, but also the core of our profession remains the same. And that's what makes it both interesting and challenging. There is a view right now, which some scholars refer to as sort of AI exceptionalism, that AI actually is different, sort of different in not just magnitude, but different in kind. I respect people who have that view. I think reasonable minds can have that view. It's just not the view that I hold. Again, to use the email as an example, and just one example, when I read sort of the legal press around the advent of email and its mass adoption sort of in the late 80s, early 90s, those conversations to me sound, if you just take the word email out and put the word generative AI in, we are dancing the same dance, always believing that we are the chosen generation where everything after us is different than everything that came before.
Yeah, Jonah, I want to talk about one of the places where I think it's a little bit unique and the impact that it's going to have on the legal profession, and that's stepping
Sure.
back prior to actually practicing and going back to law school. In your role as a professor, how are you seeing a change in students' intuition about things like research and writing with the advent of AI? I know a lot of schools have policies around how you can use it, when you can use it, what you have to disclose, and things like that. But in the seat of the student who has this tool at their disposal, how is their insight into what practicing law is going to look like changing with the use of this? And what do you think is the right balance for students as they start to have these tools at their disposal?
Yeah, I mean, ultimately, I think if you read just the general press, not the legal press, right? Education is one area where this may just be such a fundamental change, the likes of which we haven't seen in over a century. I think that's absolutely a potential outcome, and I'm seeing it. I have an 8-year-old and 10-year-old. I'm seeing it in their school just as much as in my legal writing classroom. Um, again, I go to the similarities first, right? I think it's helpful to sort of level set. The idea that there is technology that makes it easier for students to do the things that we have traditionally asked them to do, that is nothing new, right? If you ask some of my colleagues who have been teaching legal writing long enough, remember the sort of shift from book research to online research, that fundamentally changed the research process, right? But it didn't change this. It changed sort of how you do research and the skills necessary, but it didn't change the fact that you needed to learn how to do research. Um, there's another great newspaper article that from I forget exactly what year it's from, where it's a bunch of high school teachers with picket signs saying ban the calculator. And the reason they were making that argument was fundamentally, they said, how can you possibly learn how to do mathematics with a calculator in your hand, especially sort of, the graphing calculators of my youth. Um, and ultimately, we found that it just lets you learn how to do the task in a different way. All of that is prefaced to say that I do think the difference in today's law student is if we don't change what and how we teach, then they have tools that make it much easier for them to meet the expectations that we set 5 or 10 years ago. Full stop. So that's why the question ultimately comes to things like assessment, right? If half of doing well on a traditional issue spotter law school exam is identifying the issues that are there, AI is really good at that, right? And so it really makes us have to look in the mirror and say, what are the skills we're teaching and how are we assessing those skills? Big difference from when I was in law school to what today is when I was in law school, there were sort of commercial briefs. Now there are whole software solutions that basically brief every case for you, even before generative AI, right? They basically went to every case that was in any textbook and they provided a brief. Did that change how the Socratic method went and dialogue went in class? It sure did. But again, I think we need to respond to the world as it is and not as the world as we want it to be. And as educators, it is our job to both teach the core skills that go back long before our profession, right? The Socratic method, the analytical paradigm goes back to, major premise, minor premise, conclusion. We need to think about how to teach those skills, but also how to teach them in a contemporary idiom. So I don't think it answers your question, but I think it maybe provides some of the tools that would allow
Right.
each professor to do that.
Jonah, before we walk away from what you just said, there's something important that I want to unpack. You said we have to do the task in another way. I want to argue this point a little bit more because I think it's a really important one. You talk about the calculator, about arguing about whether or not we could use a calculator, about, using online research databases versus the books. Brandon has heard me, cite this example before. Look, when I practiced, we just had the books. And then I argued that we needed to have online research databases. And then, my senior partner comes in and he challenges me one day and he says, "Hey, Gold," he says, "there's a particular issue of law that I'm looking for." He says, "Go onto your fancy little, online database that we just paid for, and I'm going to go next door to the books and I'm going to go ahead and find it. And let's see who wins." Okay. So I'm here and I'm doing my, my natural language search, my Boolean searching, typing it in, trying to find it, right? I'm sweating a little bit because I'm a, first year associate. Anyway, he comes back in less than 5 minutes and he slams the book down on my desk. And he goes, I win. Right. So what was the difference there? Right. The difference there was that I was doing the task, but I was doing it in another way, but I lost. So the question becomes is why did I lose when he was able to find it? He knew to go to which one of the, if anyone is listening to the podcast remembers what's called the pocket part, right? And, and you'd be able
Yep.
to, look at the updates, that happened in the textbook, in the case law book rather. And one of the things that people are arguing, and I bring out that example because it's important here. A lot of things that people are arguing is that they become what's called a cognitive miser, right? What does that mean? It means that you lose the cognitive skills in which to perform a specific function. So if anyone's listening to this also recalls back in the day, there used to be a company called AAA. And if you wanted to go on a trip, you would go to the AAA store and they'd give you a map and then they would highlight a highlighter and they go from one end to the next. And when they did that, Jonah, they would say, just follow the map and you turn the page and follow the map, turn the page. If you give somebody today one of those, what they call the triptych today.
The triptych, yeah.
Yeah, I remember. I'm old. And when you give that to them, they won't remember at all. Or they won't have the cognitive functioning capabilities to be able to utilize that map and to follow it because we're so used to using Google Maps or Apple Maps or whatever we use. And so some argue that we've lost the cognitive functioning. We lost the cognitive capabilities to be able to perform the same thing. You would say, well, we're doing the same task, we're just doing it differently. But have we lost something though? And that's the curious question here is that when AI can just, and it's funny that I'm arguing this, but I'm doing it, I'm arguing against myself in some fashion here, as Brandon knows well, because I'm a big advocate of Gen AI. But when you say this, it's like, well, if I could just go ahead and churn out, the motion for summary judgment, and most of it's filled out. So the statement of facts, because I've given it all of the facts, and it's filled out the legal argument because I've told it what the legal argument is. And basically, I've got everything here. And sure, I've double checked to make sure that there's not hallucinated cases here, but you've lost the art of lawyering, haven't you, Jonah? Like, because all of those
So
cognitive skills are just gone.
yeah. Yeah, I mean, so let me go back to the first two examples and then let me finish where you ended, because where you ended, I think, is the real challenge. I'm less concerned about where you started, and here's why. Ultimately, the reason you lost that sort of challenge with the senior partner was, I would challenge that the rules of the game were rigged. And that is, right, he picked the thing that he knew how to do and said, you use a actually potentially less efficient way, right? Going to a natural language search of a database of all existing law is always going to be more challenging than I have the pocket part right in front of me of the right book, right? The actual sort of challenge is, well, what happens when he doesn't have the wrong book or the pocket part hasn't arrived yet? That's the more important question to me, right? And ultimately, even if you both end up in the same place and he did it from a book and you did it, and maybe it was slower because it was technical, that's fine. I don't have any concern with that. Same thing with the triptych, right? Ultimately, the triptych says, well, you don't actually need to learn ordinal directions like you're sailing a ship, right? Okay, fine. So we don't learn that skill because that skill is no longer quite as necessary. And I think that analog has analogs to what we do. So for example, if somebody says to me, well, they're never going to learn, right, how to find the right book in the library. My question is going to be, okay, why does that matter? Right? Or let's take a less that strikes me as probably too easy a hypothetical. Let's take a harder hypothetical. They're never going to learn how to brief a case, right? They're never going to learn how to brief a case because frankly, AI is pretty good at briefing cases. I would argue that briefing cases was never the goal. It was understanding the content in the case, and a case brief was a tool to accomplish that. And so now we need to ask the question, okay, does this tool allow us to still get the actual goal, which is to learn the law in the case? And I think being able to drop a case into a generative AI chatbot and be able to say, I need to be prepared for my cold call tomorrow. Please ask me questions about the case, like a professor is going to ask me, and push me in places is like private level tutoring. So ultimately, at that point, maybe that's better than the case brief. The case brief was in was a way. And so that's why I guess my goal is always asking, what is the goal? Now, I think where you ended your question, which is the thing that everybody who teaches what I teach, legal practice, legal writing, legal communication, is if it takes away all of the base level tasks and makes them easier or more automated, are we going to get to a place where you've actually never learned how to do the basics? And that's frankly our job as professors and my job as professor to explain to students and basically pitch them on why they need to be able to do some of these things, even if a tool can do them as well on the exam, perhaps, or redesign my exams to actually test what I'm testing for. Pick the right variables. So sometimes that may mean creating false constraints and not letting them use certain tools for certain tasks. That might mean instead of my exam being, please write an effective legal argument, please assess the quality of an argument that was drafted in the first instance by AI, right? That AI can't do quite well because AI was the one who drafted the argument in the first place. If you don't, so it's really thinking creatively about what is the goal and how are we going to get there.
Jonah, talking about goals and Daniel's example of that race for research kind of brings this to mind too. One of the things that you've said is that you don't believe within law firms that the use of AI and the changing of the way that we're doing these tasks will kill the billable hour, which is one of the cornerstones of legal practice in the United States. And the framework that you have for that is the charge equation, which is defined as compensation should equal hours times rate minus granted reductions minus expenses. It's a nice, simple equation for how do you calculate what the value that's really being given here. And so in your opinion, you don't think that it's inevitable that the use of AI will kill the billable hour like a lot of people fear. Can you kind of walk us through your reasoning for this equation and how you would apply it to kind of standard litigation tasks?
Sure. I'll definitely do that, and stop me if we go too deep or too long.
Sure.
I mean, ultimately, when I started thinking about this project, I was sort of faced with, as a scholar, you're always faced with, well, what are people saying about it? But when something is new, there are fewer people saying it, but they're saying it very loudly. And my read of the legal press on this, and frankly, scholars hadn't really written about it yet. It's mostly sort of actual practitioners, which is frankly the area that I like to sort of hang out in still, even as an academic. I would say the majority view was it's time. Like AI is ready to eliminate the billable hour. It allows us to move finally to where we said we were going to move for the last 20, 40, 60 years to more alternative fee arrangements. Then there's a smaller minority that sort of says, well, actually the billable hour will stay as long as it's helpful to lawyers. Ultimately, at the end of the day, if that's how we make more money, we're going to find a way to use it and clients will just deal with it. And both of those hypotheses struck me as something that we could sort of have a more nuanced and rigorous conversation about. And in order to do that, I think I really came to the conclusion you need to isolate what are the variables that contribute to why the billable hour works, right? And that's where this framework came in. And I will openly confess, as I will openly confess to anyone who asks me, I asked generative AI to help me come up with a word, right, with an acronym that worked. I gave it all of the arguments I wanted to make. I talked about all of the what I originally had in my first draft, I called them levers, and then I changed them to variables, which made me come up with this equation. It came up with the acronym, right? Which is great at. And the idea is that a law firm's compensation, and I want to put a little flag in that because the billable hour is used to sort of mean two different things. It's often used to mean both the law firm's compensation or the legal organization's compensation, but it's also how we measure individual lawyers in that law firm's productivity. And so you have to be clear on what we're talking about. When I'm talking here about the law firm's compensation. And then, what else matters? And I think there are other things that matter, but I tried to reduce it to some of the most important levers or variables, right? And that's the number of hours worked. That will always be one key issue. As you said, the rate that you can charge for those hours. A piece that I think people in the academy certainly don't talk about enough, and some lawyers don't talk about enough, is the fact that there are such great reductions that happen in today's day and age. And frankly, I think technology is helping in-house counsel and even private clients ask for those with greater specificity, and you have to calculate your expenses. And ultimately, my view was that majority view that I talked about a little bit earlier was really focused on just will it reduce the number of hours? And so their assumption was, which I call the AI efficiency hypothesis, if the hours go down, which they must, that's sort of I'm using their version of the story, then by definition, compensation goes down. But that's not how an equation works, right? If the hours go down and the rate goes up, then compensation can stay the same. And so for me, step one, the first move was, how is AI going to affect all 5 of these pieces, not just one? Step two is actually to challenge the hypothesis that hours are necessarily going to go down. But those are 2 different analytical moves that I think are really important. And I will say, and you said it in your description, which I appreciate, my view is not that this is inevitable. My argument here is a little bit more nuanced, which is to say it's not inevitable that the billable hour is gone. And maybe that's cheating as a scholar, but it's the way I'm going.
Let's be a little more philosophical and existential about this, Jonah, because, and I'm going to steal what you said before, which you said is, what is the goal and how do we get there? Right.
Mm-hmm.
So the goal is for every law firm is to generate revenue, right? Obviously, to make
Correct.
the clients happy, but we want to be able to generate revenue. And I'm fascinated with this concept that you say here about, well, the hours, hypothetically, the hours go down, then they just charge more, and therefore you're back to level set. So let's break all this apart. The question becomes this, in my mind: why can't we just go to a value-based billing system in
Mm-hmm.
professional services holistically? Because, and why do I say that? Why do I ask that question? Because if we take a look at speed to outcome and speed to delivery, speed to outcome, speed to delivery is going to, that's objective, it's empirical, it has to happen. It is going to happen much faster with AI, with Gen AI to be more specific, right? The ability to be able to say, hey, did Susie say anything bad in her emails between December and March? Inside of an e-discovery database, for instance, is going to be there. If you're doing a forensic investigation, the Gen AI is going to be able to tell you whether or not there's any receipts that the sales rep, fudged, whatever it might be. Speed to outcome, speed to delivery, that's what clients want. That's what they want to be able to get. And so if speed to outcome is going to be much faster, clients are going to be happier. And because the professional rules of responsibility says that we can't charge the same amount of hours that we would have charged, but for the fact that we use Gen AIs, so we can't charge 20 hours, we can only charge 2 or whatever it may be. So there's an ethics question there that comes up. And so I guess
Yep.
the real query is why even have this conversation about hours if we're so confident that we're going to be able to provide value as attorneys? And again, I could be playing devil's advocate here. I'm not necessarily promoting my own personal opinion
Sure.
here. But if we can go ahead and just say that we're going to provide value, then clients are going to come back to us time and time again. We're going to create, in the words of Sheldon Bowles in his infamous book, Raving Fans, we're going to create clients who are so happy that they're just going to tell all of their family and their friends and their sisters and their dogs that come to this law firm. So what is the goal? How do we get there? Well, shouldn't the goal be to drive value, speed to outcome, speed to delivery, provide exceptional service, and the revenue will follow? I mean, what, again, like, let's just restructure this entire equation that you have put together, which is very clever. And props to your Gen AI friends as well that put this together. But why can't we just say compensation is not by hours, but is driven by the value?
Yeah, so two answers, one sort of historical and one more philosophical. I'll start with the historical answer, which is this question is nothing new. I cite an article in my article from 1989 where Marianne Altman in an ABA journal says and predicts that technology will force, in her words, if I want to make sure I get them right, but basically she says it will force value-based billing, right? Because of all of the reasons that you just said, right? It will make task A that took us this amount of time faster. Our client is going to want it faster and we can provide the same service faster. Then, therefore, it is absurd to use time as sort of this like imperfect metric to get us to value-based billing. That's 1989. 2010, Richard Susskind writes the book, The End of Lawyers, where he makes basically the same argument, right? We're basically making the same argument again. So ultimately, this is not a new argument. And the reason I think the history is important is not to say that history necessarily will repeat itself or to repeat myself will rhyme, but rather to ask the question, why hasn't it happened yet? Right. To me, that is the important question because that will allow us to sort of have a better guesstimate as to whether or not AI is fundamentally different. And my view of why it hasn't happened yet is because ultimately this kind of legal fiction, for lack of a better word, or business fiction that clients want value and lawyers want to provide value for fair compensation, they have been unable to have that conversation in an effective way, and so they have held on to a historical mechanism and they basically work backwards, right? They figure out how many hours they're going to spend. And ultimately, the clients feel like they end up winning, and the lawyers feel like they end up winning by holding on to some level of the billable hour. Now, right? We know that alternative free arrangements are more popular than they ever have been. We also know they've never gone sort of above 20% of the legal market, at least yet, if you sort of look at the whole legal market. At that point, generative AI hasn't changed anything. Again, it's just the next step in all of this. That's the historical answer. The philosophical, well, let me stop there because you look like you want to jump in, Daniel.
Yeah, I'm sorry. So when you say that though, what I fear is that we may preclude the ultimate realization or benefit of what Gen AI can do for the legal profession if we're stuck in this mindset of we're going to stay with the billable hour, and if we go with Gen AI because it's going to make us faster, more effective, therefore I don't want to use it. And I want to use your historical references against you for a second just to challenge you on this. Is that
Please.
And by the way, it's funny you said 1989 because the first quote unquote e-discovery case law, off the top of my head, I can't recall the name of the judge, but he said if there is a held to which vindictive, vituperative law firm, I mean, he just went on about these lawyers. They should all be in the same held together. I thought that was actually really funny. That was 1989, and you could substitute that and say
Love
it's
it.
2025. But when you say this, though, my concern is like, we went through this iteration in 2010, right? Again, historical reference. 2010, we said technology assisted review is going to end, the billable hour. The Association of Corporate Counsel came out and said we need to have alternative fee arrangements. And so, but nobody latched onto TAR. Nobody, right? The elite few who understood the technology, Brandon being among them, really understood the technology, leveraged it, and went all out. But that wasn't the majority. Now it's like because everyone's kids and spouses and partners and friends are all talking about Gen AI. It's readily accessible. It's usable. There's no jump to trying to learn how to use it. Unlike TAR, there's no algorithm. There's no seed set. You just boom, you use it. And
Right.
so the free function of how that works makes it more accessible. And therefore, I'm challenging the historical references in the sense that is it possible? Do you think that because it's so much more accessible and usable and there's no technological hurdles to get over, it's going to be used more than other technology that we've had in the legal profession, like, oh my God, we can do an online database and do research?
Yeah, I mean, I think my answer to your question is no, I'll try to explain why, and it sort of goes to the philosophical point I was going to make, which is all of that assume like I actually think the assumption ought to be that lawyers are going to adopt generative AI. I think that anyone who's betting against that, like I don't know what odds I would possibly take on that. It's going to happen. That train has left the station. Um, what I'm less clear on, right, is how much more efficient in terms of hours spent it's going to make us, how much more business it can potentially generate, and the rates that generative AI assisted lawyering will be able to demand, right? So there is a world where the billable hour still works as a meaningful metric of law firm compensation in generative AI enhanced lawyering, right? Um, there's a world where it doesn't, although I'm fearful that in the world where it doesn't, I'm not sure that lawyers have the same value, so they should be prepared to potentially have lower compensation. So like that's sort of maybe a spicy take or a mic drop aside, but like I think if the billable hour it ends, it may not be ending because lawyers are in the same position and making the same amount of money and there are the same number of us and we're trained in the same way. The billable hour is the incumbent, right? And it needs to justify, there needs to be a justification to move off that incumbency. I mean, one of the craziest things when I started researching this article was the fact that I just assumed, and again, this is like, contemporary exceptionalism, that this was always the way that lawyers build themselves. And when I learned that history, I was shocked to find out this is a 60 or 70-year-old phenomenon, which in the grand scheme of the legal profession is actually quite small, right? My prior work has been on client confidentiality, which goes back 4.5 centuries. The billable hour is, less than a quarter of the age of the attorney-client privilege. So it's still relatively new. And it's also embedded, and this is another argument I make in the article, is like, this is embedded not just in how we bill our clients, but how we organize ourselves in law firms, how we choose who gets to make partner, how we assess sort of how good a lawyer is. It is deeply embedded in the institutions of the practice of law, at least in the United States. And so when you take it out, you have to fill that gap with something else. So the opportunity cost is meaningful. So that's my answer to your question, Dan.
I want to go back to your mic drop moment there.
As I was saying it, I was fearful that you would, but let's go for it. Why not?
No, well, because it walks into the question that was blooming in my mind as you and Daniel were having that discussion, that so AI changes the hours portion of this formula for us. It's inevitable that it will change that portion. And I'm curious your thoughts on before we get to the utopia that Daniel's talking about of being able to just do value-based pricing in it, which
Right.
is a whole different can of worms, because how the client sees the value versus how the firm delivering it sees the value,
Sure.
that's going to be a really difficult thing to come to a meeting of the minds on. But we could talk about that on a different podcast. For today, I'm thinking about the transition from where we are and the importance of the billable hour now to how the billable hour might evolve over the next couple of years with that AI enhanced lawyering. Hours will go down. What other factors in that formula do you see litigators having room to actually push to try to maintain their revenue? So there's one world in which lawyers just don't make as much money. Firms aren't as big as they are. There are fewer attorneys out there in the market. If we as an industry say, well, we don't want that, we want things to kind of stay status quo. So where can we maintain that revenue in this, or where are clients most likely to give us the room to maintain that revenue in this formula?
Yeah, it's a great question. And it's one I've been thinking a lot about. And again, these are all predictions, not answers. So I'm open to, and I'm curious what you guys would say as well. This is why I think the equation helps, right? Essentially, the constraint that you're asking for, Brandon, is that compensation stays the same or better, right? So C does not change.
Right.
The assumption is hours per individual task go down, right? If that is the case, right? If we're doing scenario planning, if that's the case, what do we do if we want to keep C at where it is? So one option, right, is that lawyers' rates will continue to increase. We've actually seen that in the technological age. Lawyers' rates are higher than they ever have been. And that's not just true at the top end, although the top end is what gets you the Wall Street Journal headlines that now we have lawyers billing at over $3,000 an hour. But that has always, the highest billable lawyers have always, in some ways, set the market all the way down the tree, if you will. So rates can go up, and I think lawyers can tell a really compelling story to their clients about rates going up, which is a lot of the time we were spending was things where we really shouldn't have been charging you quite so much money for. We've been able to outsource all of that, and the nuggets that you're actually paying me for are exactly what I'm trying to do. Now, remember, compensation stays the same. So from the client's perspective, right, they are paying for value. And this goes back to Daniel's point. In their mind, they are being charged billable hours, but they are trying to get value, at least corporate clients, right? So in their mind, what they're saying is this task, right, is worth $10,000 to me, right? And hours have gone down, but this task is worth $10,000 to me. So why not go from, why we won't use the $3,000 number, but why not go from $600 to $800 or $1,000 or $1,200 as your rate? Because to the client, nothing has changed, only to the lawyer. If anything, the lawyer is the one who gets all the benefit because they have to work less. in a profession where we know the amount of hours that lawyers have to bill and work is one of the reasons why our profession is struggling so much, right?
Yeah.
And the second benefit is it opens up more time to work. And so there's a
Right.
world in which lawyers end up making more money, assuming that the pie is not a set pie, which is another argument I make, based on history. So that's just one way of many, but you get to tweak. That's the great part, right? If you're a practicing lawyer, you get to choose what are the levers or what are the variables that you are willing to play with. Now, is there a moment when clients are going to say, no, I'm not going to pay $10,000 for 10 minutes of your work? Not going to do it.
Hmm.
I don't know, right? I actually think if we accept Daniel's premise as that clients actually pay for value, not for hours, the answer should be no, right? The rate ought not to matter as long as you are providing the value. It's just an atmospheric that looks funny on the bill.
Yeah.
And to go back to the ethical question that Daniel raised, that's entirely consistent with the current approach to ethical rules. We cannot say this task would have taken 20 hours. Therefore, we are going to charge you for 20 hours, even though it took us one. That is verboten, although Virginia is, I think, playing with that idea right now. But it is entirely consistent as I read the model rules on fees and state-based rules on fees to say you signed on the dotted line to say that you are going to pay $10,000 an hour, right? That is reasonable given the value you are getting. You worked 1 hour, please pay me $10,000. And so to me, it really is a math equation. The danger, right? What I worry about is a world where the pie doesn't get bigger in terms of number of hours, but maybe the pie gets smaller because people are doing their own work and they're not bringing it to lawyers. Then you get a downward spiral where there's a scarcity mindset. So rates go down because there's too much supply of lawyer hours. Rates go down, hours go down. You get to the point where you're only left with a few folks who can make any money.
Yeah.
That's the sort of like death spiral that scares me as someone who believes in the power of the legal profession. And I promise the bar associations will do their very best to make that not happen. Whether or not that's a good thing is a whole other question, but like they're going to try. Yeah, so that's my answer to that.
Well, one quick follow-up on that, since we're talking philosophically, your prediction or your diagnosis,
Yeah.
do you think that our focus on the billable hour over the last 50 years, combined with the hype around Gen AI now and how much time it's going to save you, do you think it will change or impact what clients are seeing as the value of work that's being done by attorneys? Like, are they still going to say this is worth $10,000, or do they automatically have in their heads, oh, this should take less time, therefore it's no longer worth $10,000. It's only worth six.
Yeah, I mean that to me is the real question,
Mm.
whether or not clients are focused on value and whether they are going to devalue lawyer work because Gen AI is
Yeah.
perceived to do more. Another version of that is more work goes in-house because in-house lawyers have more tools to sort of do some of the work that they might have farmed out. Um, I think that may change the way the profession looks, size of law firms, location of law firms. I have said in the past, and I've gotten a lot of pushback on it, but I think it may lead us to a world where law firms get either bigger or smaller, but don't stay the same size. Um, but yeah, that is absolutely. I think that is a lot scarier than the fact that AI is going to make us more efficient. I think it is much scarier from a perspective of an outside counsel practicing lawyer, uh, that clients will just start saying, well, actually, what you do is not that valuable anymore, right? You have become little more than than someone we bring in only in the rarest of circumstances, as opposed to you are our relational helper on a regular basis. That to me is more scary than us getting super efficient. Because I'll tell you, I actually think there is a world in which AI makes us better, but not quite as efficient as the efficiency gains are not quite as big as we think they're going to be.
I want to let that sit there for a second. Actually, that's actually really interesting. There was someone else that we had talked to on a podcast where they had basically said that one of the things that makes lawyers lawyer, and I had made this statement once before as well, but I'll much more likely attribute it to the other podcast guest, is that what makes us humans and what makes us greatly great lawyers is our ability to be able to be better critical thinkers. And I
Mm,
guess until such time that Gen AI has the ability to have critical thinking skills and think with reason, I do think that that's what separates us from machines is our ability to be able to
absolutely.
have like empathy and humanity and compassion for another human being. Because as much as Gen AI tools can mimic that of a human, it's just that it's mimicry and somewhat being about mockery and as to how a human operates. And so when I think
Hmm.
about what your answer was just a moment ago, Jonah, I think about this now through the context of I think that the the people who really truly understand the AI tools and leverage it to the best of their ability will be able to have speed to outcome, but be able to be better critical thinkers because there's going to be more time to think. And we make this joke that thinking is really hard, but because the locomotive is always going 1,000 miles an hour, and in order to slow down long enough to really think, that is not a commodity, right? And so you have to be able to spend the time to be able to think. And so on the one hand, maybe that task is now actually worth $10,000 because you're doing it much faster and getting that much more work. And so the speed to outcome, speed delivery is there.
Hmm.
But then now the other thing I wonder is this is how do you even determine what the hourly or what the rate should even be or what the value should even be? For years, legal operations professionals have made a lot of money off of spend optimization, right? Cost containment,
Yep.
going over to a corporate legal department and saying, show me all of your invoices and all your billable rates by timekeeper, by role, right? And hourly and by issue of law and by jurisdiction. And holy cow, like I could save you 10%. I'll make 10%. I'm going to save you 10%, right? And then that 10% may come
Right.
out to $50 million in savings to the legal department. But you can't, if we get to the point where people start using Gen AI more, right? And their time spent less, then all of that historical trend data is out the window, isn't it? Right. So
Yep.
what do you even do with any of that historical trend revenue? If things do go in this direction of Gen AI, I mean, would you say that we are redefining exactly what our profession is? Do we get to that point where you said this is billable hours only 50, 60 years old? Do we get to a point now where like we've hit that inflection point in our profession where holy cow, like we're actually going to change the way we do this now? Or is that just naive thinking?
No, I mean, I don't know that it's certainly not naive thinking. And I mean, maybe it goes back to the first question you asked me about, is this the next step or is this a jump shift, right? Ultimately, I still come down on the next step, but I think the argument you just made is in my view, the best and the most sophisticated version of the it's a total shift argument. But I would push back a little bit on the fact that it's the first such jump shift. I mean, if you think about it, right, one of the reason I started researching confidentiality at all was because when I was a summer associate, summer 2009, I was sitting in Brendan Sullivan's office, one of the greatest trial lawyers of his generation, and I wasn't ready for the question that he was going to ask all the summer associates. And the question he asked was, um, "Ask me a question." And I'm thinking, "Oh no, what am I going to ask this like incredible trial lawyer?" And the question that came to me in that moment, which fundamentally changed my scholarly trajectory for the next 25 years, or 20 years at this point, was what has changed the most from when you started practicing at Williams and Connolly as a first year associate to now being the senior partner all these years later? And he said the answer is one word: documents. He said, when I started trying cases, one banker's box of documents was a big case. Two bankers' box of documents was a massive case. And so when I went to trial, which I did often, right, I would know every single word in those 1 to 2 boxes. That's impossible in my practice today. So I've had to fundamentally change what it means to be a litigator. It literally bears very little resemblance to what I was doing when I first started, right? It may be the natural progression of, but bears very little resemblance to. And that has implications for confidentiality, which is where my interest started. And it has implications for the billable hour and it has implications for practice. I think we are a constantly changing profession. I think we are incredibly responsive as a profession to the moment in which we live, which is actually why I'm such an optimist about the future of the legal profession, because I think lawyers will always play a role in society. And if anything, what we've seen is they play a greater role in society. People may dispute whether or not that's a good thing or a bad thing, but like from my perspective, um, we may change what we do and how we spend our days, but we are absolutely not going to, technology is not going to change those core skills that you were talking about of counseling and empathy and using the systems that are available to us to live in a sophisticated civil society. And nothing about generative AI is going to change that. But sure, what a lawyer's day is going to look like, yeah, that's going to change. I think it's crazy not to think so, but I also think it's a little bit exceptionalist to assume that that's never happened in the 60 years we've had the billable hour.
Well, Jonah, time has flown on this. I feel like we could keep talking these topics and others that you've written on for hours. But what we've covered today, I think, has been fascinating. It has been really insightful, and we want to thank you for the time that you spent with us as we wrap up today. And on behalf of the NeLI audience, and of course Daniel and myself, just really want to express the appreciation we have for your thoughts and for taking the time to share them with us and our audience today.
Yeah, I appreciate you having me and asking such amazing questions, and I'm happy to continue the conversation with anyone offline, online, and I hope Daniel keeps pushing me a little because you've given me new things to think about, and you guys are doing great work, and I think this podcast and NeLI generally really is playing such an important role in these conversations and being thought leaders at this really important part of our profession, and so I'm grateful to be a part of it and learn a little bit about y'all and be on the podcast today.
Thank you so much. If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in e-discovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of e-discovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.